The next bill we're going to jump to right now is Senate Bill number 511. We have Jordan Goyet. We have Jordan Goyet on the phone. Welcome to the committee. Mr. Goyet, you're testifying on Senate Bill 511, which is by Senator Kano, an act relating to criminal procedure, bail, and recognizance. If you could keep your comments to 5 minutes, we'd appreciate it.
Great. Thank you so much for letting me speak tonight. Madam Chair and members of the committee, I hope you'll strongly consider supporting S511 by Senator Kano, who I really commend for introducing this. She represents the part of Pawtucket that I was raised in. And personally, this affected my own family. In the late 1990s, my older brother was stopped in East Providence by the police there and found with an ounce of cannabis on him, which the committee is later going to be considering later this week legalizing that amount, which is great. But at the time, he was treated like a drug kingpin. He was recommended to be held without bail. And he was held in the ACI for 2 weeks because he was considered a flight risk due to the fact that he lived just over the line in Attleboro. And I remember my mother told me, I was a toddler at the time, so she couldn't even go to his arraignment. My aunt went for her and said, it was a good thing you didn't went because you probably would have collapsed. Because they dragged him in shackles and the orange jumpsuit like he was Pablo Escobar for an ounce of cannabis. And I think another story that, if people don't know this one, that should be looked into is the case of Khalif Browder, a young black male from the Bronx, New York, who was arrested for a stolen backpack that was later turned out to be his upon his release, and held in Rikers Island for 3 years without trial. His family had to raise money from a neighbor, and then they couldn't even make the bail with that. And 2 years after his release was finally secured, he committed suicide. There's so many of these cases where people get picked up on small offenses like shoplifting or larceny. They're not criminals then, they just did something. They just maybe messed up. They did the dumb thing. Sending them to the ACI and holding them for months, years maybe, without trial, that turns them into criminals. That turned Khalif Browder into an agitated, aggressive young man that had to be locked up in solitary confinement for two of the 3 years he was held in Rikers Island. And I really think we don't want that to happen to any child here. You've already heard some cases of where it almost did. So I hope you'll strongly consider supporting the bill, and I thank you for the time tonight.
Thank you, Mr. Goyet. Any questions for this witness? Seeing none at this time, thank you for joining us this evening.
Thank you.
Next up, we have Mike DeLauro, Rhode Island Public Defender's Office. Welcome to the committee, Mr. DeLauro.
Yes, thank you.
You may proceed with your testimony. If you could kindly keep it to 5 minutes, we'd appreciate it.
Yes. Well, thank you, Madam Chair, members of the committee. You have a number of bail bills that have been before you and will be before you during the course of this session. And some of them are different. You heard one last week from Senator Quezada. This one tonight from Senator Kano is a little bit different. And as I said, there are other bills pending in both houses right now. And I think the reason for that is pretty clear. There's a growing recognition in this country that the way we do bail ought to be looked at and ought to be reformed. And I think that's one of the reasons that, as we speak, 30 states more than 30 states are considering are considering legislation that incorporates bail reform. Some of them, like this bill, 511, that's before you tonight, addresses the problem of monetary conditions of bail. And really, I think what it boils down to is this. Monetary conditions of bail, especially in misdemeanor cases, are unfair. And I think there are two examples or hypotheticals that I can give you that demonstrate that. Let's assume for a moment that Senator Archambault and I are charged with identical crimes. We have the same criminal record. We have the same ties to the community. Everything is the same. There is one difference. The difference is that Senator Archambault has money and I don't. What happens then is Senator Archambault is able to post bail and await trial on the street, and I am not. But there are other ramifications, too, and it's the same scenario, only let's say this. Let's say I have just enough money for a bail bondsman, whereas Senator Archambault can post his bail in the form of money or property. When the case is over, Senator Archambault is going to get his money back, his bail money back, his property back, and I'm not, because I went through a bail bondsman, and paying the bail bondsman a fee, I'm not entitled to get that back. This is not anything new for this committee. In 2008, the General Assembly enacted legislation that was introduced at the request of my office that eliminated cash-only bail. I gave you the citations to that in the written testimony that we provided. So there's nothing new about this. This is just another step in what we believe is the right direction. The legislation that's before you tonight also is similar to Senator Quezada's bill 315 in that it makes the involvement of the pretrial services unit in providing relevant information to the judge before setting bail, makes that involvement more robust. And this is entirely consistent and effectuates what the General Assembly did in 2017 as part of justice reinvestment. Finally, the legislation incorporates, and there's nothing new or revolutionary about this, but incorporates the definition of, quote, pretrial release, unquote, from Rhode Island General Laws 12-13-1.3. You also have that citation and what that statute says in our written testimony. I respectfully suggest that you take a look at it. If you have any questions, I'll be happy to try and answer them for you.
Thank you, Mr. DeLauro. Any questions? Yes, Senator Archambault.
Yes, Mike, good to see you. Welcome to the committee. Of course, I think you have the order reversed on who would have the money and who doesn't. I think you should have put me in the later category. But that said, my only concern, and you and I have talked about this bill in the past, and I like it. I think it's a step in the right direction as part of the whole justice reinvestment. The only issue is if someone did have serious issues regarding concerns of domestic violence. Remember that tragic case maybe a decade ago, maybe it's close to 2 decades ago. The guy was released and got out, went down to Coventry and killed his spouse.
I remember, yeah.
Yeah, so I'm within the parameters of shall be released to pretrial services. I read it and I had some concerns around that, the language that sort of opened the door 100%, that you have to be released. Can you amplify on that and just help me to be a little clearer on what you're trying to put together?
Sure. So when we were reading this, you read it very carefully, we saw that there were some issues regarding statutory construction that maybe, or maybe not, should be addressed. And I haven't spoken with the sponsor, but I would say that there are. It is a great bill, but could it use some tweaking? Yeah, probably. And I think I put that in our written testimony that we're happy to work with anyone to, address any concerns or application type issues that have arisen, including the one that you mentioned.
Madam Chair, may I follow up?
Yes.
Yeah, thank you. You know, you know exactly what I'm talking about, and I'm trying to be tactful because I don't want to derail the bill because I think the spirit of it's a good bill, but that loophole has to be tied up. Yeah, it has to be discretion for a judge, district superior to be able to say, look, this person's got a history, I'm concerned, and the reason for this, you know, the following reasons, the totality of the circumstances within the discernment of bail, that this person does need parameters that enable them to not get released to pretrial services. And, you know, there are a host of reasons what would constitute that you and I know just from empirical experience. But anyways, I appreciate your comments and, you know, if that issue were tweaked, I think it's a good road. It goes with justice reinvestment.
Thank you, Senator. Any other? Go ahead.
Madam Chair, if I could just respond
yes.
very briefly to what Senator Archambault has raised. You know, the bail reform legislation that's been introduced this session already, you know, they go in a number of different directions. Some go further than this, some not as far as this. What we see this bill as doing is strengthening what is already part of the law of the state, which is there is a heavy presumption in favor of release on personal recognizance. And we don't, as currently written, we don't read this bill as abolishing monetary conditions of bail completely. In fact, there are some, and that's why I mentioned the statutory construction issue, that there are ways to do what we think the bill wants is you know, meant to do. And, you know, so, like I said, we're happy to work with anyone to make it a better bill.
Thank you, Mike. Any other questions of committee members?
Madam Chair.
Seeing none at this time, thank you for joining our committee this evening.
Thank you very much.
Next, we move to Senate Bill number 513 by Senator Burke, an act relating to courts and civil procedure in particular actions, death by wrongful act. Good evening, Addison Norrett. You're speaking on Senate Bill 513. If you could keep your comments to 5 minutes, we'd appreciate it, and welcome to the committee.
Thank you. Good evening, Chairwoman Coyne and honorable members of the Senate Committee on Judiciary. My name is Addison Norrett, and I'm here this evening to testify in favor of Senate Bill 0398. I recently became aware of this legislation and learned that there is no law in Rhode Island prohibiting a child from being married. I'm not going to repeat the statistics, but I want to inform you from a 13-year-old's perspective how childhood marriage is disgusting. As a 13, almost 14-year-old girl, I never even think about boys, and I could never imagine having the responsibility and obligation of being married. Not just to cook and clean, but to carry a child. Many childhood marriages were the younger girl and adult male. Most of the time, this results in forced sex. This should not be a crime since the two are married. Teenagers should not have to worry about being married, do the cooking, cleaning, or being locked in a bedroom. The statistics show that not all were for this reason. They were for other reasons. But nothing changes the fact that no child should be forced into a marriage and have an obligation to run a household and do what they are told. I take pride in my education, and many people in this situation wouldn't be going to school. I think about my future all the time, and it consists of finishing high school, going to college, working, and then start building a family in my late 20s. I bet that many of the girls regret not living their life and doing something good with it. I called in tonight to ask all of you to support Bill 0398 and end childhood marriages.
Thank you very much for your testimony, Ms. Norrett.
Thank you.
Did you also, I had you also down for Senate Bill 513. Did you want to testify on that one too, or just 398 this evening?
I think I was just going to do 398. Thank you.
Okay, thank you very much for your testimony. Any questions for Ms. Norrett? Yes? There are no questions at this time. Thank you for joining us this evening.
You're welcome. Thank you very much.
Next, we turn to Senate Bill number 514 by Senator DeMario, an act relating to courts and civil procedures, sexual abuse or exploitation of a child. I believe we have Rep. Carol Hagen McEntee on the phone from the Rhode Island House of Representatives. Welcome to the Committee on Judiciary, Rep.
Hey, thank you, Chairwoman, and thank you, members of the committee. Can you hear me?
Yes, we can. You may begin your testimony.
Oh, okay. Well, this bill put in by myself, many of you will remember back in 2019 and 2018 when we went through quite a process to get the extension of the statute of limitations for childhood sexual abuse in civil cases. It was a long, hard battle. I call it Annie's Law, and in honor of my sister, Dr. Ann Hagen Webb. So I know that Senator Archambault asked a question earlier about whether or not this was in direct relation to a current decision by the Supreme Court, by the, Superior Court, and that is correct. What we're doing here today is clarifying the meaning of perpetrator for the purpose of this bill. And if you read the language of the bill, the language of the statute that we passed 2 years ago, you'll see on page 1 of your legislation, line 15 through 18, we didn't even alter the definition of perpetrator. We left it as is, as it's been determined by the court through the criminal law and the civil law. Now, in light of the recent decision, I felt it was incumbent upon me to come back and clarify the meaning of perpetrator. When I read the decision in the final page, it says even if the court determined that the statute was ambiguous, the finding would not alter the outcome of the case because it is clear that the legislature intended to limit the term perpetrator to the actual abuser. Now, further, she states, in making that determination, the court gives great weight to the fact that the legislature chose not to adopt the definition of perpetrator set forth in the previous statute, knowing the construction our Supreme Court gave to the definition in Kelly versus Mark Antonia. That is so far from my intent or the intent of, I believe, the legislature at the time. Anybody who followed this hearing back in 2018 and 2019 would know would be most certain that never did I intend to create a loophole for perpetrators and for any perpetrator that's as defined in the law for childhood sexual abuse. If you look to our criminal statutes, and there's many of them, there's 11-37-3.1, duty to report sexual assault. It's a crime. 11-1-6, conspiracy. It's a crime. 11-1-3, liability for aiding, abetting, counseling, hiring, or commanding offenses. You're held as part of the underlying crime as a criminal as a principle of the criminal undertaking. Now, we as a legislative body have every right to clarify what we meant when we passed these laws. And that's what we're doing here today. And again, I just want to say the intent of the legislators and the intent of myself was never to remove any person or entities that aid, abet, assist, conspire with another individual to perform or commit sexual assault or exploitation of a child. And we've never intended it to be taken out of the meaning of perpetrator by creating a loophole for these people. Now, you're going to hear testimony from many victims tonight that are going to tell you how their perpetrators, whether it be Catholic Church, whether it be Episcopal Church, whether it be the Boy Scouts, the perpetrator, the institution protected the perpetrators. They concealed, they transferred, and all of these actions allowed the perpetrator to continue in his criminal activity, which I believe exposes them to criminal liability. And in that, if they are criminally liable, they should be civilly liable for the same action. So with that, if there's any questions, I'd be happy to answer them.
Thank you very much, Representative. Any questions for Rep. McEntee? I see none at this time, and thank you for joining our committee this evening.
And thank you, Chairwoman, and thank you, members of the committee.
For sure, thank you. Next up, I believe we have Mr. Timothy Conlon. Good evening, Mr. Conlon. Welcome to the committee. If you please let me know who you represent, and if you could keep your comments to 5 minutes, we would really appreciate it.
I'll certainly try to do that. Thank you so much. My name is Tim Conlon, and I represent a number of victims of child sexual abuse, many of whom cases are closed, and many of whom have cases yet to be filed, and many of whom have cases before the court. So thank you for taking the time to address this important issue. I know Representative McEntee just discussed her intent and her understanding of what was intended. And I just want to try to reduce this down to some relatively simple points, because I understand the question, if you will, in terms of how this is impacted by existing cases and such. But I think it's important that the legislative body understand how its acts are being construed and the practical import that Annie's Law had. Certainly when Annie's Law passed, it was championed as nothing other than a tremendous breakthrough, if you will, in terms of expanding the time in which a claim could be brought on behalf of a victim of child sexual abuse. And it did indeed reference a pre-existing, if you will, definition of perpetrator versus non-perpetrator. There was some language with some examples, and this is where things went off the rails a bit. But be this as it may, the notion of perpetrator and non-perpetrator defendants goes back to 96 with the prior version of the Act. And Kelly versus Mark Antonio, which is a Rhode Island Supreme Court decision, is very, very, very clear in distinguishing between negligence, which if you're liable, well, there's a set of rules as it relates to the statute of limitations, versus perpetrators and criminal conduct. And it was Kelly and its progeny were very clear. The language out of Kelly was that it is not just the person who has sex with the child, but a person who actually aids or assists in the commission of child sexual abuse, such that they would be subject to criminal prosecution. So basically, our pre-existing scheme, if you will, under 9151 before Annie's Law, was that criminals got different treatment, if you will, than non-criminals. Negligence had one set of runnings of statute of limitations, but the remedies available if you had criminal misconduct on part of a person, or for that matter an institution, were substantially different. And I think that's certainly intuitively obvious as to why it would be that you'd give more remedies to people where people are responsible criminally for their child sexual abuse than you would as to mere negligence. So what, in essence, the issue now comes down to is whether, in passing Annie's Law, the legislator intended to remove a class of criminals from the scope of the perpetrator status, if you will, and the protections that Annie's Law established. And in essence, those who would oppose this bill would suggest that it should have no impact on persons who are criminally responsible if they didn't actually have sex with the child. So they would take that language that pre-existed the legislation about how a person who is criminally responsible, such that they would be subject to criminal prosecution because they aided and assisted or aided and abetted the commission of child sexual abuse, and they would read that out because of the language in a statute that, frankly, you folks passed. Now, mind you, again, you just heard from one of the authors of the bill that's certainly not what was intended. But rather than leaving this just, and I certainly will make all those points to the Supreme Court, but rather than leaving this out for debate, this organization has the opportunity to speak clearly. I would, from a public policy point of view, point out that we have pimps, we have people or institutions trafficking in children, we have a whole class of people who are criminally responsible as aiding and abetting or conspiring in causing the sexual abuse of children such that they could be prosecuted criminally, but didn't actually have sex with the child. I would give you the most obvious example out of the media lately of Ghislaine Maxwell, who is certainly alleged to be basically pimping, supplying, helping, recruiting, making a pipeline of young women for Epstein. So, again, whether she is or she isn't, that's a matter that you try. But I would argue that if she's pipelining girls into Epstein, she is certainly a criminal co-conspirator. She knew perfectly well what was going on with the girls that she was putting in. The reading of the statute is such that Ghislaine would be off free from criminal liability, not because she's not a criminal, but because she didn't have sex with the child. Now, I don't think that's what the legislation was intended to do. I don't think it was intended to carve out a class of criminal and give them isolation from civil liability. But that's the argument that is being made based upon some lack of clarity, for lack of a better term, or you could call it creative lawyering on the other side, I suppose. But the bottom line is, if we're into closing loopholes and we don't want people to be able to profit off of the sexual abuse of children and then avoid civil liability, even though they're criminally responsible, by simply saying, well, but I didn't actually have sex with the child, then you want to pass this bill. Thank you so much. Have a good evening.
Yeah, thank you very much, Tim. Are there any questions for this witness from any members of the committee? No, hearing none. Thank you very much. You have a nice evening. Our next caller is Mr. Carmen Durso with the Law Office of Carmen L. Durso. Good evening, Mr. Durso. Good evening, Mr. Durso.
Yes.
Yes, welcome to the committee. You may proceed.
Okay, thank you.
Thank you.
Mr. Chairman, members of the committee, thank you for giving me this opportunity to speak to you about Senate Bill 514. I am speaking in favor. My name is Carmen Durso. I'm an attorney licensed in Massachusetts. My office address is 175 Federal Street, Boston. I've been practicing law for 55 years, and for the past 30 years, I've concentrated on representing survivors of sexual abuse in claims against perpetrators and the institutions where the abuse occurred. I was going to speak to you about why it is that institutions should be held responsible for sexual abuse under this legislation. But I think perhaps I need to emphasize something a little different based on testimony that I heard in the House hearing on this bill. And that has to do with the question of the constitutionality of the legislation. I'm not capable of speaking about the constitutional law of the state of Rhode Island, but I can tell you that the U.S. Supreme Court has ruled as recently as 2003 in the case of Stogner, S-T-O-G-N-E-R versus California, that expired statutes of limitations can be repealed to revive a civil action. In other words, that you can have retroactivity. I heard testimony from an opponent of this bill suggesting that that's not possible. The U.S. Supreme Court has said otherwise, and that is based on precedents that go back to 1945. So I hope that when you do hear people who They don't try to convince you that this is some strange or unusual thing that's been done. Majority of the courts that have considered this matter in the United States, I believe, have decided that you can have retroactivity. Your legislation is quite similar to what we adopted in Massachusetts in June 2014, except that we had a clear understanding that as to non-perpetrators, suits could be brought retroactively. It's been almost 7 years since that legislation was adopted. Nothing catastrophic has occurred. The economy of the state has not collapsed. And the reason is simple. Companies, institutions, youth-serving organizations have insurance. Their insurance comes into effect to protect them with regard to city suits. They have this insurance for ordinary negligence, people who fall down on their premises, things of that sort. None of them fail to have this insurance, so they will be protected from that. The other thing I'd like to say to you is that I hear this said to be about the Catholic Church in Rhode Island, and to be sure there have been problems there. But the Catholic Church is a very small part of the overall problem of institutional sexual abuse. Institutional sexual abuse occurs far more frequently in education. There was a study that was done for the U.S. Department of Education in 2004 that estimated that 10% of all children in schools are subjected to sexual abuse. The person who did that report updated it about 10 years later and said that if anything, the statistics were worse. So having institutions able to be held responsible for failing to protect children from sexual abuse is vital. This legislation would do that, and I hope that it's adopted by you. Thank you.
Thank you very much, Mr. Durso. Are there any questions from any members of the committee for this witness? Hearing none, thank you very much for your testimony. You have a nice night.
Thank you.
Thank you. Our next witness is Catherine Robb with the Child U.S. Advocacy Office. Good evening, Ms. Robb. Good evening.
Good
Catherine.
evening.
Yes, good evening. Welcome to the committee. You may proceed.
Thank you, Vice Chair and committee members, for allowing me to testify in support of Senate Bill 514. My name is Catherine Robb. I'm the Executive Director of Child U.S. Advocacy and a survivor of child sexual abuse. Starting at age 9, I was repeatedly sexually assaulted by someone I knew and once trusted. So I speak here as an expert, an advocate, an attorney, but also as the voice of that little girl. At Child U.S. Advocacy, we work on child protection legislation all over the country. And I just want to give you sort of what's happening across the country. There is a clear national trend by lawmakers in responding to this epidemic of child sexual abuse, which the data presently shows that 1 in 5 girls and 1 in 13 boys will be sexually assaulted before their 18th birthday. Since 2002, 37 states, the federal government, and the District of Columbia have extended their statute of limitations. 21 jurisdictions have revived their civil statute of limitations, and 13 jurisdictions have eliminated the statute of limitations for child sexual abuse. This year, 30 states have already introduced statute of limitation reform bills, and 17 of those are revival. Revival laws serve the common good as they incentivize institutional change of better child protection practices and policies. So the national trend is clear. The sky is not fallen. Some will cry, well, the courts will be flooded. The courts have not been flooded, and I can share lots of data on that. Some will also cry, well, there will be false claims. There is zero evidence of false claims. I can share as much as I can because it's hard to prove a negative that way. Some will also cry, well, we don't do this for other types of torts. I would argue these are not typical personal injury claims. These are not car crashes or slip and fall cases. And it's not about the severity of the injury, but it's about the unique type of injury. We're talking about the sexual assault and rape of children. These are very, very different civil wrongs, and there are wrongs that silence their victims, as the average age of disclosure is age 52. I personally did not publicly share my abuse until I was in my 40s. Some will also cry, institutions will go bankrupt. But any bankruptcies are voluntary Chapter 11 bankruptcies. They serve the wrongdoer. They get to reorganize their debts and liabilities. It's a new day for them, not for the victim. They live with their pain of sexual abuse their entire lifetimes. Victims become a number on a spreadsheet. Their voice is lost. And most importantly, the wrongs of others are kept hidden as there is no discovery. Some will also cry, well, it's not fair, due process. As an attorney and as an American, I believe in due process. But constitutional rights are not absolute. Safety and common good often outweigh due process. Many states have held revival laws constitutional, including my home state and your neighboring state, Massachusetts. And as Mr. Dorso just mentioned, the Supreme Court decision in the Stogner decision. Let the legislators legislate and let the courts decide issues of constitutionality. Moreover, there are safeguards. The rules of civil procedure, the rules of evidence, they remain in place, and plaintiffs must prove their cases. My final point is this. The court's distinction between perpetrators and non-perpetrators grows out of their interpretation of the plain language of the statute and legislative intent, both of which the legislator is fully within their right and authority to clarify, as they do here. Senate Bill 514 seeks to clarify civil liability that case law already confirms. Rhode Island courts have long found criminal aiders and abettors liable in tort context. Some of those cases are in my written testimony. I cannot imagine that the good lawmakers of Rhode Island would intend to excuse criminals, aiders and abettors and the like from civil liability, especially when we are talking about horrific criminal acts of sexual abuse of children. I hope Rhode Island can follow the national trend to protect children and to hold those who cause harm accountable, and I thank you for your public service. I am happy to answer any questions.
Thank you very much, Ms. Robb, and thanks for your courage in coming forth and spending so much time in this area to help other people as part of your own healing.
Thank you.
Yeah, God bless you. Any questions for this witness? Hearing none, thank you. Have a nice night. Our next witness is Ann Hagen Webb. Good evening, Ms.
Hello?
Webb.
Yes.
Yes, welcome to the committee. You may proceed.
Oh, thank you. Thank you, Chairwoman Coyne, Vice Chair Archambault, and the members of the committee. I'm here to testify in favor of Senate Bill 514. Many of you heard my testimony in 2019 chronicling the sexual abuse I experienced as a child. Today, I'm here in my more professional hat as a licensed psychologist in Rhode Island and Massachusetts and a victim advocate specializing in childhood sexual abuse. Failure to report sexual abuse of a minor is a crime for a reason. It aids and abets more sexual abuse of minors. Unreported criminal abusers move on to new, unsuspecting child victims, leaving a trail of destroyed lives behind. The employers and organizations that protect them and send them on to new positions of unsuspecting communities are just as responsible for those destroyed lives. Childhood sexual abuse and rape victims rarely come forward early. The median age of reporting is 52. Sexual crimes are usually difficult to prove in a criminal court due to the lack of material witnesses. Civil litigation is often the only avenue for justice and the only opportunity to make public the names of perpetrators and their accomplices. Every time a sexual perpetrator is publicly named in a criminal or civil court, the children of Rhode Island are safer, protected from becoming unwitting victims of that sexual predator. Over my 20 years of specializing in childhood sexual abuse, I have seen scores of victims abused by serial predators. Almost always, those predators have been protected by the organizations who employ them. Although my major expertise is with people abused by clergy, I have worked with those abused in private schools, public schools, and the Boy Scouts. In all of these cases, the perpetrators were given free passes from the church, school, or organization to move on to new employment and a fresh victim pool. Protecting the perpetrators, not the children. I've prepared employment timelines for many of the perpetrators you'll hear about tonight through other people who are giving testimony. A quick glance at each of them clearly demonstrates the complicity of the organizations and the employers who knew but moved them on, or in some cases let them continue in their employ. Tonight you'll hear testimony from two victims of Father Robert Marcantonio. They were abused at the same parish, but during two different assignments there. The Chancellor of the Diocese of Providence knew in 1970, yet Marcantonio was transferred to Iowa and eventually back to Rhode Island, abusing children all along the way. You will have testimony from three James Talbot victims, abused decades apart in two states. Yet his employers and supervisors suspected he was a predator even before he was ordained. You will hear from victims of the notorious Brendan Smith. One will speak tonight and one has written testimony. Brendan Smith victimized dozens of children in Ireland, Northern Ireland, Rhode Island, and North Dakota. His supervisors in Ireland knew about his rampant abuse of children. Irish Cardinal Brady admitted as much in a book published this week. Bishop McVinney of Rhode Island knew about this abuse in 1968, yet Smith went on to sexually abuse more unsuspecting children on two continents. Howard White, an employee of the exclusive private school St. George's in Middletown, sexually abused many minors while employed there. The headmaster knew, but let him move on in good standing. He went on to abuse children in several states for more than 2 decades. He should have been stopped here. We've heard the excuses from institutions. Oh, we didn't understand the extent or the importance or the danger of child sex abuse in the 60s or 70s or 80s. How gullible do they expect us to be? If parents put their children in harm's way, their children are removed by child services. Yet the court's interpretation of our current law gives organizations, employers, and supervisors a free pass to do exactly that. This cannot stand. Make no mistake, even with this law in place, it is extremely difficult for childhood sexual abuse victims to successfully sue the organization. The church, school, Boy Scouts, or other organizations have very deep pockets. They and their insurance companies hire the best lawyers who bury opposing lawyers in motions and paperwork. They never hesitate to overturn a decision based on a technicality. Rarely, if ever, is their defense strategy, we didn't do it. Essentially, they have a free pass. These accomplices and protectors of criminal child abusers are clearly perpetrators themselves. They should be just as civilly culpable for these horrific crimes that destroy and damage the lives of children. Please pass Senate Bill 514 tonight. Thank you.
Ms. Webb, thank you for your testimony. Are there any questions from any members of the committee for this witness? Hearing none, thank you very much. You have a nice evening.
Thank you. You too.
Thank you. Our next witness is James Scanlon. Mr. Scanlon.
Thank you, Vice Chairman Archambault and honorable committee members. My name is Jim Scanlon. I'm a resident of Providence, Rhode Island, and I'm here to support Senate Bill 514. In the fall of 1977, at the age of 15, I was raped by James Talbot. At the time, he was a Jesuit priest, a teacher, and hockey coach at Boston College High School in Boston, Mass. However, I'm not here to recount what happened to me. I've done that over the last couple of years when we extended the statute of limitations here in Rhode Island and testifying in 2018 and 19. But what I am here to testify about tonight is why it didn't need to happen to me and the 88 other boys before and after me, a couple of who are also testifying tonight, and why we need to hold the institutions that knowingly allowed it to happen, we need to hold them accountable. In 2002, I read a front-page article in the Boston Globe revealing how not only systemic child abuse was in the Boston Archdiocese of the Roman Catholic Church, but how complicit the leadership was in not only knowing it happened, but facilitating it happening over and over again. There was a long series of events between 2002 and 2005 after reading that story that led to me coming forward criminally against Talbot. And I testified before a grand jury and was helpful and part of us helping to put Talbot in jail, which ultimately turned into 6 years of jail time served for him in 2005. During that 3-year investigation, until his ultimate guilty plea in January of 2005, I was able to see in horror how complicit my Jesuit high school had been in facilitating his move from Boston College High School in 1980, which was 1 year after my graduation, to Cheverus High School in Portland, Maine. It was through written communications that came up during the investigation and the trial between the leadership of both schools that we discovered, quote, incidents had happened at BC High, and it would be best that we move him to Cheverus, where he could continue in his service as a teacher, coach, and priest. Ultimately, it was without no supervision, restrictions of his service, or, for that matter, discipline for what he had done. During that discovery, I learned he had been removed from prior assignments prior to coming to BC High, both as a priest and prior to becoming ordained as a priest. As a result of those incidents prior to BC High, he was moved to St. Luke's Hospital, and I believe you have a timeline on his history in Baltimore. After spending time in St. Luke's Hospital, which is there to serve child sexual predators, he was eventually transferred from there to Boston College High School, where I eventually met him. Talbot and the institution he worked for didn't stop while he was at Cheverus, in Cheverus, Maine. In 1998, he was credibly accused by Michael Doherty, a Cheverus student, who had been groomed and raped in a similar manner as I had. And although moved from the high school, his duties, although removed from his duties at the school, he was still allowed by the Jesuits to work in a local parish in Freeport, Maine, where one of his victims was a boy named Ben Wheeler, who was first raped as an 18-year-old boy during his, quote, private first confession with Talbot. When Talbot walked him out to his proud mother, waiting in the car, asking how he did, Talbot patted him on the back of the head and said, he did wonderful. This was after forcing this 8-year-old to perform oral sex on him at his first confession. This hidden abuse would continue another 4 years for Ben, based on the testimony during Talbot's second criminal trial in 2018, in which he went on to serve another 3 years in prison. Ben was able to testify last Wednesday before the House Judiciary Committee, but was unable, because of work commitments in the short notice, been able to testify tonight. During these 5 decades of child sexual abuse by Talbot, the institution, which in this case was the Roman Catholic Church, moved a knowing child predator from one school or parish to another, knowing what he would do, solely to protect their power and their money, and with no regards to protecting these kids. During the movie Spotlight, which is a movie about the Boston Globe Spotlight team, there is a line stated by Mike Resendez, one of the Spotlight reporters. It could have been you, it could have been me, it could have been any of us. They knew and they did nothing about it. Well, it was me, it was Ben, It was Michael Doherty at Cheverus High School. It was Donnie who will speak before me, and these institutions did nothing about it, and they need to be held accountable. I thank you for your time, and I ask that you please support Senate Bill 514 and hold the guilty institutions accountable for their actions, or in some cases, inactions. Thank you.
Yeah, Mr. Scanlon, thank you very much, and God bless you for your courage and your testimony and coming forth tonight. Very articulate, and you're helping so many people. Thank you for that. Any questions by any members of the committee? No, hearing none. You have a nice night, and thank you again. Our next witness is Donald Hurld. Mr. Hurld?
Yes.
Yes, welcome to the committee. You may proceed.
Thank you. Good afternoon, Vice Chairman and committee members. I thank you kindly for this opportunity to be heard on support for Bill number 514. The gentleman who just spoke, I've had the pleasure of coming to know a bit, as I believe I was one of Talbot's first victims back in the 60s. At that time, you didn't talk about priests. I couldn't talk about it. I didn't talk about it for 40 years. 40 years of hell. 40 years of missed opportunities and not being all that I could be. 40 years of not being able to tell anybody what I had been subjected to. The fact that Talbot turned me over to one of his friends for alleged tutorial help, but as he started massaging me to relax me, I knew that Talbot had put me in his hands. So not only did these pedophiles capitalize on their access to these kids, but they also passed them around. And then the hierarchy relocated them to institutions where they were unknown, but carried on their old ways of being pedophiles. I really can't say much more than Jim said, except I'd like Jim to know how much I love him. I know this isn't the time to say it, but he's my hero. My dirty little secret never would have come out. Not as a alleged tough kid from a tough neighborhood in Boston. My dream in life was to become a lawyer by way of BC High and Boston College. I joined a federally funded program run by Jesuits to help inner city kids acquire the skills needed to pass the entrance exams required at the best high schools. I passed the exams and entered BC High in September of 1967. Unfortunately, the price I paid has cost me dearly and does to this day. My personal mentor and best friend, so I thought, was Jesuit James Talbot. We established a friendship to the point where he was welcome in my home, broke bread with my family and I, and I was just ecstatic. The fact that this charismatic Jesuit had designated me as his personal favorite, quote unquote. How lucky was I, or so I thought. After morning classes, when we were getting tutored by the Jesuits, we would go up to the Jesuit Center in Western Mass. And for a kid from the projects, growing up with 10 people in one apartment in the concrete jungle, I was now getting tutored by men of God in the morning and enjoying myself outdoors in the, to me, was a country, which Western actually is just a very affluent suburb, but to me was the country. They had swimming pools, tennis courts, basketball courts, and a golf course. One day out in the golf course, a situation arose, and Father Talbot, I swore I would never call him Father Talbot. Jim Talbot and I were caught in a compromising situation. So that's at least one priest that I knew. The wrestling that we had every day turned into aggressive and violent sexual abuse. I backed off from Talbot, went to school at BC High, and despite starting out good, my grades fell apart, and so was my life. I was approached by another Jesuit who said that Father Talbot had told me how special I was to him, and he had asked this Jesuit to help me help myself by enabling me to study privately. The area where I studied privately turned out to be his residence on campus. I was told by him that Jim Talbot had arranged this on my behalf. Didn't take long to realize what was happening. And my whispers were realized as he massaged and inappropriately touched me to help me relax, or so he said. I ran out of the building never to return. No one from the school ever tried to contact me. I got severe beatings from my father for leaving school and not being able to tell him the truth. Unfortunately, my father was a sadistic alcoholic. The life that I thought that I had found was slowly slipping away. So since then, as a freshman in high school, I left there, I ran out. I left home. I was a teenager out in the streets, doing what I could do to survive. Drinking every day, fighting every day. Eventually I turned to drugs. Faced some time incarcerated. I'm on my fourth marriage. I know I have to take responsibility for a lot of my behaviors, but logic dictates that the behaviors I endured at the hands of Talbot and others certainly negatively affected me. But I really didn't have to worry because this is going to be my dirty little secret no one would ever hear. Until Spotlight came out their articles, I saw Talbot's name in the paper and that he had abused other people. Then there I knew I could no longer be silent. Then when the movie came out and I saw the actor who portrayed Jim Scanlon, who just spoke, I literally had a breakdown. I still break down thinking that others were subjected to this demonic actions by these alleged men of God. They always remind you that they were men of God. That's why they could do what they could do. Only God and them can understand. I sure in hell can't. As if the abuse wasn't horrific enough, the fact that these alleged men of God were sent elsewhere, out of state or to other educational institutions, I still haven't gotten over it. I'm now 67 years old. Fortunately, I've been in therapy for 3 years, and I'm starting to find myself the person that I could never be. Instead of being a lawyer, I was on the other side of the bench. I was a criminal. Instead of having good things in life for my kids, I had anger, and I had to work 2 full-time jobs to take care of my family adequately because I was denied the education and access to the future I had been promised. So there's not much more I can say except that the horrors don't change from the day it happened. And when you find out of future victims that you feel you could have prevented from them being victims, the guilt goes on. So please, stop the guilt, stop the horror, stop the carnage, stop making people like Jim Scanlon, one of the finest men I've ever seen, have to testify on his own behalf. It's not fair. It's time for it to end. Thank you for hearing me, and I apologize for being a little out of sorts. It's quite emotional. Thank you.
Mr. Hurl, thank you. Don't ever apologize. You're still that tough kid from Boston, and I want to commend you on the courage it took to testify and how many people you're helping. And anyone who would do something like that under the guise of God is a demon in the flesh, so they don't deserve any pass. Thank you for your testimony. Very, very powerful, and God bless you for having the courage to come forth and help so many others. Thank you, sir. Our next witness is Dr. Herbert Brennan. Dr. Brennan?
Yes, it is.
Yes, welcome to the committee, sir. You may proceed.
Yes, thank you very much. Thank you, Chairwoman Coyne, Vice Chair Archambault, members of the committee. My name is Hub Brennan. I am 63 years old. I grew up in, live in, work in the town of East Greenwich. I'm an internal medicine doctor in private practice and have been so for over 25 years. As background, I was the assistant chief of the East Greenwich Fire Department before leaving for medical school in 1988. I have always been active in civic affairs and, like you, try to give back to the community. Most recently, I've been immersed in the effort to get ahead of our COVID pandemic. I've served on a number of local, statewide, and international boards and commissions. I'm president of the Kent County Medical Society and past president of the Kent Medical Staff, a former board member and trustee of Kent Hospital and the Care New England Health System. I'm an advisor to the Office of the Health Insurance Commissioner, and I am a clinical advisor to the Federal District Court, District of Rhode Island. I've actually worked in concert with your committee in the past, as I was the first non-attorney to serve as the chair of the Rhode Island Judicial Nominating Commission. And please, if this sounds impressive, if it's not meant to do so, I offer you that because, quite simply, those activities over the years represent, my rambling activities of a man trying to find a meaningful purpose in his life and trying to fill a void after a terribly disrupted childhood. Madam Chair, members of the committee, I revealed publicly for the first time just 3 years ago on the House side and in front of your committee that, in fact, I was raped and sexually assaulted as a child by Brendan Smith, a priest assigned to a Lady of Mercy parish between 1965 and 1968. At the time, I was between 8 and 11 years old. I learned that he had a 30-year history of horrific offenses against children in the standard Catholic pattern. He'd been moved about from parish to parish and even overseas from Ireland to America as his behaviors were discovered. I'll reference quickly a document by Bishop Accountability, a chronology of Brendan Smith. It has 90 entries of his stops along the way, and I'll just summarize them. The ones he got caught for in March 26th of 97, he pled guilty to 74 charges of indecent and sexual assault, 7 boys and 13 girls in the Republic of Ireland. He pleaded guilty to 62 offenses of indecent assault on males and females in a hotel, a cinema, a boathouse, an abbey, a convent, and other venues in several countries within the state. Dates from January 1st, 58 to December 31st, 1991. Also pleaded guilty to 12 charges of sexual assault on males and females from January 1st, 91 to December 31st, 93, taking place in 9 countries spread over 4 provinces. Clearly, a world-class pedophile living a horrible life and leaving a trail of misery behind. When I was at a Lady of Mercy, as a child, Smith would call from his rectory across the street and had the nuns pull me out of my 2nd or 3rd grade classroom. There I would wait in the principal's office until he entered and took me across the hall to the nurse's office, where he would close the door and do what such monsters do to innocent children. And I'm sure you've heard details of that activity by other testimony this evening. I offer a couple of things. My hometown newspaper at the time, the Greenwich Pendulum, on the front, a smiling Brendan Smith. For the past 3 years, the popular Irish cleric has worked mainly with CYO and youth sports activities. On his last day, in fact, he will keep an appointment with your Pendulum photographer to take pictures of the title-winning cadet girls basketball team that he ran off with the Little League title only a week ago. Stunningly here, hundreds who attended a buffet in his honor last Sunday night at the Greenwich Club. This world-class pedophile comes to the United States, abuses me and others in my neighborhood and community. The church keeps it quiet, spins this as a priest returning to his homeland, and they have a event in his honor, sending him off. From the Providence Journal Bulletin, February 29th of 68, smiling Brendan Smith on the front, the title, "Their Best Fan is Going Home." Three documents, actually, as to what was truly going on. We have a letter that you have in your file from Abbot Colwell of Holy Trinity Abbey in Killincroft Abbey in County Cavan, Ireland. This is from the Bishop of Providence at the time. I regret to inform you that I have sent Father Brendan Smith home. I was under the impression that he was doing very well in the parish to which he was assigned. To my amazement, it is now reported to me that he doesn't measure up on several counts. His rapport with the adult parishioners has not been happy. He seemed dedicated enough to the young people, and in some cases too much. So we feel that for the good of the parish and the souls, and for all his own sake, he should return to his monastery. And I also have a letter here that has been submitted from Reverend Bruno Mulleville in Augsburg, Germany, 8th of June, 1995, in which he outlines receiving the call from Bishop McVinney that Brendan Smith was returning home. And he makes it very clear in his testimony that his activities and reasons for being sent home were very, very well known. Stunningly, and most importantly here, is a letter brought to our attention from the Diocese of Providence, dated November 17, 1994. Possible reply, this is an internal document to be used internally only. Possible reply to query from Sue Reed in London if she calls back. Sue Reed was a heralded European news reporter regarding Brendan Smith. This is a canned reply that is to be used for any press inquiry. We know that of Brendan Smith what we know of Brendan Smith is quite limited. He is a member of the Irish Norbertine Order, formerly known as Canons of Regular Promontory. Father Smith served briefly in this diocese during the 1960s at the request and positive recommendation of his religious order superior, apparently in hopes that the climate here would help his asthma problem. He left on his own accord and has not returned, nor have we had any further contact with him. Underline, if asked, : there is no evidence of any wrongdoing on his part while he lived in Rhode Island. For additional information, contact his religious supervisors in Ireland. The fact that this priest spent so much time harming children landing here in the United States goes back to Ireland, where he is ultimately convicted. And the Diocese of Providence puts together an internal document for any press inquiries that reads as I have outlined, is prima facie evidence of a cover-up. It's evidence that the diocese is not a bystander, a neglectful bystander in this. The diocese is, in fact, an active participant in furthering the ongoing activities of this horrific pedophile. As it relates to the specifics of this bill, the lobbying office of the Providence Diocese, the Rhode Island Catholic Conference, argues that the bill impedes the administration of justice and does little to protect victims. The diocese officers indeed offer an expert opinion therein, as they know all about doing little to protect children, myself among them. The diocese presents itself to you via their testimony as your constituents. This is a false premise. In fact, the diocese has conducted itself more likening a criminal enterprise and is more accurately cloaked as a criminal defendant. The church has effectively run a child sex ring for decades, for generations. They want you to differentiate between an individual perpetrator and a neglectful organization. The church, the Diocese of Providence have not been neglectful. As that letter points out, that internal memo points out, they've been active participants and the systematic rape of children. The basis of their opposition is that this bill will hurt them financially. That's their argument. That being held legally responsible for their criminal activities will hurt them financially. Imagine that. The other industry in opposition, their insurer. I'll leave you with a very brief vignette that has always chilled me to the bone. I was in my office one afternoon after I had testified before you, and I was paid a visit by a fellow firefighter that I worked with decades before. He came in and sat with me in my office, and it was a long and rambling conversation, really going nowhere, but I knew my friend did not want to leave. He finally looked up at me and he said, "Hub, this almost happened to me." He held his two fingers up and he said, "I came this close." His parish priest put him in a car and took him to a lakeside cabin. When they arrived at the lakeside cabin, there was another priest there with a young child. Words were exchanged between the two priests. My friend was returned home by his priest safely. He was frightened that he came so very, very close to being a victim just like myself. A question maybe not for you, a question better for the Attorney General is who owned that cabin? Was that cabin across state lines? But I think it's further evidence of the diocese role and, again, the systematic rape of children and ruining of their lives. Thank you, committee chairs, bill sponsors, and members of this distinguished committee for your time.
Doctor, thank you very much for your testimony. Very compelling. Any members of the committee have any questions for this witness? No, hearing none. Thank you. You have a nice night.
Thank you, sir.
Thank you. Our next witness is Kyle Parati with The Mountaineer, parentheses, Mountaineer Publishing Company. Good evening, Kyle Parati.
Yes, sir.
Yes, welcome to the committee. You may proceed.
Yes, thank you for allowing me to testify in support of Senate Bill number 514. My name is Kyle Parati. I'm a reporter with The Mountaineer. It's out of Waynesville, North Carolina, just west of Asheville. I wrote a series of investigative articles about Howard White, an Episcopal priest who's pleaded guilty in 2 states to charges related to the sexual abuse of children. Not only was Howard White a priest, but he was also a teacher and chaplain for private schools in multiple states and a guardian ad litem here in North Carolina. In recent years, White has pleaded guilty to charges related to abuse of children within all of those capacities. With that in mind, I'll lay out 3 key elements of White's timeline that I believe implicate those institutions. White pleaded guilty first in Massachusetts and received an 18-month sentence before pleading guilty here in North Carolina, where he got 12 years. In the case where he pleaded in Boston, it was related to the sexual abuse of a child from St. George's School in Middletown, Rhode Island. The two were visiting Boston. And that's not the first time White abused children while traveling. There are also cases of abuse that occurred while traveling to Canada for a camping trip, in Washington, D.C., and even in England. It's important to note, according to a 2016 Boston Globe story, White's abuses were reported to administrators of St. George's in 1974. The headmaster at that time, who I think has since passed away, took the complaint and fired White. But a lot of people aren't certain whether or not or how he may have told other folks of that abuse. It eventually came out that he did write a letter noting that White had sexually abused at least one child, but it's not really even known if that letter was seen by many people or anyone. From there, White went to Chatham Hall in Virginia. When I spoke with the former headmaster who employed White, when I spoke with him for my reporting, he swore that he never received any word or letter that would indicate to him that there was any kind of abuse at St. George's or anywhere else. And he also further went on to say that he believed White had never sexually abused anyone while at Chatham Hall. Whether the St. George's headmaster failed to pass the letter on to the Chatham Hall headmaster, or whether the Chatham Hall headmaster lied to me, either way, one of them failed not only that victim, but future victims as well. Not long after leaving Chatham Hall, after a couple of years in Asheville, in 1984, he became rector of Grace Church in the Mountains here in Waynesville, North Carolina. Recently, just about a year and a half ago, he pleaded guilty to numerous felonies related to the sexual abuse of 4 children while there, and that's what led to his current 12-year sentence. Had White been held accountable at the time allegations of abuse first surfaced in 1974, he would not have been able to further abuse children as a trusted member of a trusted institution. Furthermore, 2 of the victims related to White's time in North Carolina were abused basically due to White's access to them in his capacity as a guardian ad litem. Both of those were boys who'd had behavioral issues in the past, including one who was a runaway, which I think made them even more vulnerable to such abuse because they would be less likely to come forward and probably even less likely to be believed. In both of those cases, he used alcohol to lure his victims and to gain their trust. He eventually resigned as a guardian ad litem in the early 2000s, but records related to that weren't made available to me because it was considered a personnel matter, so I'm not certain exactly what records are maybe related to that. What I consider to be the worst example of the church's or any other institution's failure to hold White accountable came in 1996. To understand that, you have to go back to 1969 when White abused an 11-year-old second cousin while visiting home in West Virginia. The victim in that case, whom I interviewed several times, was addicted to alcohol for decades following the abuse, but it wasn't until the 90s when he became sober that he decided to come forward to try to hold White and the church accountable. Like so many other victims, he didn't come forward until decades after the abuse. At that time, White was still rector of Grace Church in the Mountains, again in the 90s, and considering White was a co-defendant along with the Episcopal Diocese of West Virginia in that case, the church here in Waynesville must have known. Not only did the church not take action, like firing him or conducting its own investigation, the church allowed him to continue to be around children until his departure in 2006. In fact, one of the victims whose abuse he pleaded guilty to a year and a half ago was abused in 2004, which to me is an example of that institution failing because they weren't held accountable. These examples should paint a clear picture of how institutions, and not just religious institutions, as well as communities themselves, can enable the continued abuse of children by serial offenders. Had the church held him accountable and had word of his abuse been made public in 1974, numerous other children would have never been abused. And not only did turning a blind eye enable White's future abuse of other children, but it essentially serves as an advertisement to those that have those proclivities that certain institutions are where they can go to abuse children with impunity. Through holding these institutions accountable, they will then be held or compelled to hold themselves and their members accountable, and closing the loophole within the existing law will ideally bring at least the state of Rhode Island one step closer to doing that. Thank you for your time.
Thank you very much, Mr. Parati. Are there any questions for this witness from any members of the committee? No, hearing none. Thank you very much. You have a nice night.
Thank you.
Our next witness is Pasco Troya with Survivors Speak Rhode Island, LLC. Good evening, Pasco Troya.
Yes, sir.
Yes, good evening. Welcome to the committee. You may proceed.
Thank you very much.
Thank you.
Thank you for allowing me to speak for Bill 514. My name is Pasco Troya, a survivor of childhood sexual abuse and co-owner of Survivors Speak RI. Please let these words sink in. The Providence Diocese is a cold-hearted corporation. In 1992, I joined a lawsuit against the Providence Diocese Corporation with 37 other child abuse victims. 10 years later, we won a small victory for the exact subject we are here to address: child abuse in the Catholic Church. I discovered during those 10 years that the diocese does not care one iota about victims. They tell the media they care about every one of us. Behind closed doors, they say and do the complete opposite. Their actions speak much louder than their words. Months ago, a news reporter asked Tobin about child abuse victims. Tobin's reaction came across sincere. Combined with his caring words indicated that he always cared for child abuse victims. As his cronies at the Providence Diocese kept fighting to stop and dismantle the bill passed in 2019, which allowed victims to sue both of their predators. Their sexual predator priest, along with their predatory corporation, the Providence Diocese. This corporation placed innocent children right next to the hands of predators. This corporation silently moved these same predators around to protect the institution. This corporation was part of an international cover-up for decades, more likely centuries, protecting pedophile priests instead of protecting innocent children. The Providence Diocese allowed priests the freedom to molest, rape, and destroy innocent children on their very own properties. The properties where their employed priests were able to live, work, and play 24 hours a day, 7 days a week. For the church to work so hard against these cases proves that Tobin does not care one bit for child abuse victims, as he indicates in his public addresses. Instead, Tobin lies. He lies like the Pope, who retired years ago, to move the stink of child abuse a little further from the Vatican, which all sides must agree that the stink of child abuse has never left the church. Being an abused child destroys a life. Being a student at St. Mary's School in Cranston, Rhode Island destroyed my life. I was molested by priest Mark Antonio in St. Mary's School, St. Mary's Rectory, even in the basement of St. Mary's Church. Every time I was molested, it occurred on the property of the Roman Catholic Church, better known as the Providence Diocese Corporation. If the molestation rate of children in the Roman Catholic Church occurred at any other worldwide corporation, their doors would be closed, locked, and the keys thrown away decades ago. The reason these doors remain open are because the main goal of this institution is to preach and teach about God, Jesus Christ, and the Holy Spirit, and to share faith, hope, and love with their parishioners, the exact opposite of what they do. Instead, they literally use God's name to hide their dirty deeds behind. In spite of the diocese, I truly love God. When the bill was passed in 2019, the church played their poker hand very close to their chest. They even supplied a list of priests who abused children starting in the 1950s. St. Mary's Church in Cranston had the most predator priests in the state. The number was 8. They supplied the list of predator priests to give the impression they care. So the men came forward to sue under the new law of 2019. They had their legs cut off at their knees. When they were informed they could sue the priest, but they could not sue the cold-hearted Providence Diocese. When child abuse occurs at your institution and you dish out $3.2 billion in America and another $1 or $2 billion to other countries around the world, it proves the child-abusing priest you allowed in your institution, along with the international cover-up you supplied, places the institution and the priest at the exact same level of blame. Without the institution's involvement, the rate of childhood abuse would have never occurred at so many locations or at the rate that it has. Give these victims what they deserve. Everyone knows these molestations occurred. Please Do not abuse these childhood victims, this time as an adult. Allow them the right to hold the parties accountable who were. The Rhode Island Catholic Conference wrote last week to keep the statutes of limitations because they enable claims to be investigated and decided fairly, while facts are fresh, memories are vivid, and relevant evidence is still available. I got news. When you're abused, child, the facts ripen and the memories increase over time and never fade. The diocese is the one who caused these suits to stagnate over time and now complain these cases happened too long ago. A ploy which I believe this wholehearted corporation has been planning for decades. My name is Pasco Troyer. If you are abused or know someone who is, please check out the website survivorspeakri.org. Thank you so much for letting me speak on behalf of this bill.
Mr. Troyer, thank you very much for your testimony. Are there any questions from any members of the committee? No, thank you very much. You have a good evening.
Thank you, sir.
Thank you. Our next caller is Robert T. Houlihan. Good evening, Mr. Houlihan.
Yes, hello.
Yes, welcome to the committee. You may proceed.
Okay. Thank you for giving me another opportunity to speak on this matter. I guess I wanted to say first that my case was one of the cases that was, to me, inexplicably dismissed by a lower court judge recently. And I think it's fairly well known what a blatant, arrogant, and rampant criminal Norman Demers was. And again, I don't want to concentrate on him so much as and how that has affected me personally, but the fact that, you know, the management of the Catholic Corporation at every step along the way not only protected Norman Demers, but enabled him in an extremely egregious way, and that the church continues to do this. They underreport the number of predators that they have. They continue to employ people that are, you know, known predators. I feel like, you know, I've read the Establishment Clause. I don't understand how church has not been served with a RICO warrant, you know, and how, you know, Congress will enact a law respecting the establishment of religion. And I think the second part, the Establishment Clause, where, you know, Congress should not interfere with the religion, doesn't extend to the point of criminality. You know, they have fielded blatant, arrogant, and violent criminals like Norman Demers, who assaulted me when I was a young child with another man, who trafficked who knows how many boys from different places around the world, and was protected every step along the way. And now I don't see how the Catholic Church is any different than General Motors or Monsanto, where, you know, if the management has, you know, enabled and covered up blatant crimes, it needs to be held accountable. And, you know, if that's troublesome to them, I mean, they have the great privilege of not paying taxes, and they just want more. You know, they illegally lobbied for and received SBA PPP funds recently to the tune of billions of dollars. I don't understand how that's legal. You know, I think the management of this corporation, this church, is extremely arrogant. It believes it is the law, not just above the law. And I feel like, you know, if they're not held accountable, my faith in the rule of law in the United States is greatly diminished or gone. I don't know what more to say about them. I think all of the criminality is well known. They want to say it's in the past, but yet, you know, we saw this priest Pucci a year or so ago saying that pedophilia never killed anybody. That made international headlines. A guy from Warwick. You know, how many other guys like that are hidden and protected and moved around, etc. I just feel like this is something that they shouldn't be allowed to get away with. I think it's a violation of the, First Amendment of the Constitution that they have not been more fully investigated, and I don't know what more to say about that.
Thank you very much, Mr. Houlihan. Are there any questions for Mr. Houlihan? Thank you very much. We're going to move on to our next bill, which will be Senate Bill 535. And our first witness will be Tony Mills. Good evening, Tony Mills.
This is Tony Mills.
Yes, good evening. Welcome to the committee. You may proceed.
Thank you. Good evening. I'm here today to testify in support of Senate Bill 535. Thank you, Senator Oya, for sponsoring this bill in your introduction. My name is Tony Mills. I'm a graphic designer and website designer. I have been working as an independent third-party contractor in Newport, Rhode Island for the past 30 years. The purpose of this bill is to add amendments to Rhode Island laws 9.128 and 9.128.1 to exempt independent third-party contractors from liability in lawsuits when a client who has hired their services provides them with a person's name, portrait, or picture for use in the company's print or digital media for commercial use without that person's permission. In May 2019, I was added as a defendant in the third amendment of a lawsuit as a website designer because the plaintiff was in 2 employee group photographs on a company website. I was hired as an independent contractor and supplied with employee photographs and instructions to include them on the company website I designed. The photographs were taken by a professional photographer hired by SHS Pest Control and as such, company-owned digital assets. The photographs were of employees taken at work during business hours. The basis of the lawsuit was the plaintiff, now ex-employee, was in photographs on the company website after her employment was terminated. The plaintiff had not given written permission to use photographs that included her on the company website. Because I was named specifically as a website administrator in responses to the plaintiff's original complaint, I was added as a defendant to the third amended complaint. Another independent contractor, Katie Dyer, was likewise added as a defendant to the lawsuit as the company's social media manager. The plaintiff was in a group employee photograph posted on the company Facebook page. Katie had not posted the photograph. In fact, she was not hired until 3 years after the photograph was posted.
That's fine. Thank you, Senator. Thank you.
As independent third-party contractors hired to work on a company's website and social media accounts, we should not be held liable for the actions or omissions of a company that are out of our control. In this case, the responsibility was on SHS Pest Control as employer to have signed releases and permission from all employees for photograph usage, both during and after employment. It was not our responsibility as hired contractors to ensure those written permissions existed or to know the employment status of people in photographs supplied to us. Rhode Island laws 9.128 and 9.128.1 should not apply to third-party independent contractors. Instead, the responsibility should be solely on the client as contractee to have the required permissions for materials they provide to a contractor to work with. Today, I'm asking you to please approve passage of this bill to protect independent third-party contractors from liability in lawsuits when a client who has hired their services provides them with company-owned assets that include a person's name, portrait, or picture for use in the company's media without that person's permission. I thank you for your time and attention to my testimony. Thank you.
Thank you for your testimony, Ms. Mills. Any questions from committee members? Seeing none at this time, thank you for joining us this evening. Next up, next up is Katie Dyer. Good evening. Good evening,
Hello?
Kate. Yes, good evening, Katie Dyer. You're on. You may proceed with your testimony on S535.
Okay, thank you. Good evening, Mr. Chairman and members of the committee. Thank you for giving me this opportunity to testify tonight. My name is Katie Dyer, and my company is Cato Dumont. I've been in business in Newport, Rhode Island since 1987. I'm talking to you today in support of Bill S-0535 for both myself as a public relations professional and social media manager and my fellow independent contractors, including website designers, developers, and administrators, social media managers, graphic designers, videographers, social and digital marketing consultants, etc. I had much the same harrowing experience as Tony Mills, the web designer who has spearheaded this effort for Bill S-0535. In my capacity as SHS Pest Control Social Media Manager, I am the other independent contractor who was added as a defendant to the lawsuit described by Tony. The plaintiff in the lawsuit was a former employee of SHS Pest Control who appeared in a group employee photograph posted on the company's Facebook page after her termination. Not only had I not posted the photograph, I was not hired by SHS Pest Control until 3 years after the photograph was posted. Regardless, after I was sued, I had to hire an attorney, respond to the lawsuit, and in my defense, serve my own interrogatories on the plaintiff and SHS Pest Control. When my lawyer approached the plaintiff's lawyer about dismissing me from the lawsuit, given that my hire date was 3 years after the posting of the Facebook photograph, he responded in the negative because he felt that the current statute allowed him to cast a wider net and seek damages from someone like me. As a result of this situation, my husband and I endured significant emotional distress in addition to the financial burden. As third-party independent contractors hired to work on a company's website and social media accounts, Tony Mills and I should not have been held liable for actions or omissions that were out of our control. In this case, the responsibility was solely on our employer, SHS Pest Control, to have signed releases and permissions from all employees for photograph usage both during and after employment. It was not our responsibility as hired contractors to ensure that SHS Pest Control had those releases or to know the employment status of people in photographs provided to us by SHS Pest Control. In this specific case, I had no knowledge of the plaintiff or even what she looked like. Not only had I not posted the group photograph on SHS's Facebook page that the plaintiff used for a lawsuit, I could not have pointed her out in the group photograph because I had no idea who she was or what she looked like before I was sued by the plaintiff and included in the lawsuit. Photographers have been granted an exemption from liability in cases such as Tony and I endured. This begs the question why actors in our capacity aren't granted the same treatment, especially given that we are further removed from the source. Please correct the omissions in the current law and protect third-party independent contractors from unwarranted liability by passing Bill S-0535. Thank you for your time and this opportunity to testify. I'd be happy to answer any questions.
Thank you, Ms. Dyer. Any questions from committee members for this witness? Seeing none at this time, thank you for joining us this evening and thank you for your testimony.
Oh, thank you very much.
For sure. Next, we move to Senate Bill number 677, an act relating to courts and civil procedure, traffic tribunal. I believe we have Miss Julie Hamill from the Rhode Island Judiciary on the line. Good evening, Miss Hamill.
Good evening, Chairwoman Coyne and members of the Judiciary Committee. My name is Julie Hamill. I serve as General Counsel to the Rhode Island Judiciary, and I appreciate the opportunity to briefly address the committee this evening in connection with 4 bills which are before you. First off, Senate Bill 677 is essentially a cleanup bill. That is not to say it isn't an important bill, but it is essentially a clarification that was requested by the Traffic Tribunal to ensure that that tribunal has jurisdiction over violations prosecuted by the Department of Environmental Management of violations of 2013-16, which is the harassment of hunters, trappers, and fishers. The bill will also clarify the fine amount by adding it to the schedule of violations. And I thank Senator Raptakis for introducing that bill on behalf of the Judiciary. The second bill this evening is Senate Bill 679, which would amend General Laws 1535, which is the statute empowering certain state officials to join people in marriage. The proposed amendments do two things. The first is that it would add the administrator of the Supreme Court as an individual authorized to perform marriages. And secondly, the bill would clarify that the current administrators of all courts within the unified judicial system are likewise authorized to perform marriages. The statute currently makes reference to former administrators being authorized to do so. We're just seeking a clarification. And my thanks to Senators Archambault and Burke for introducing Senate Bill 679 on behalf of the judiciary. The third bill that is before you is Senate Bill 727. This is a bill which seeks to amend the statute pertaining to the Ronco system. As many of you know, the Ronco system is maintained by the Department of Attorney General's BCI unit. And the judiciary has an interface with the AG's office through which Superior District and Family Courts submit protective orders for uploading into the Ronco system in accordance with 1229.8.1. And Ronco stands for Restraining Order, No Contact Order System. So that system houses all of those protective orders for all of our courts. Currently, the Ronco system does not accept protective orders wherein a juvenile is the named defendant. Essentially, the system only allows the input of adult information. Because of the way the statute is currently written, the family court has been sending protective orders over to the BCI unit, but due to the limitations of the Ronco system, those protective orders essentially just sit in a queue, never to be entered. And while we understand that these juvenile records are not entered into the system due to some federal regulations that prohibit juvenile information from being housed there, we would like to be able to stop sending those juvenile defendant cases to the BCI unit, but cannot do so until a statutory change is made. I want to be clear, however, that information pertaining to protective orders that are issued against juveniles will still be accessible to law enforcement through the AG's office. The BCI unit at the AG's office can access the judiciary's juvenile database upon request, and so that information will still be available to law enforcement. I would also like to note that the judiciary has discussed this bill with representatives from the Department of Attorney General. We do have the support of that office, and I anticipate that if you have not already received a letter, you may receive one shortly after this hearing. And finally, I would like to thank the sponsors of that bill, Senators Lombardi and Oyer, for introducing it on behalf of the judiciary. The final bill that I would like to address this evening is Senate Bill 728. And again, this is a cleanup bill which will remove the remaining references to minors from the district court protective order statutes. This will essentially remove any confusion that still exists, which would create some conflict as to where a person needs to go to file a protective order on behalf of a minor. All of those filings must be made in family court, and so we essentially want to remove any reference whatsoever to minors procuring protective orders from the district court. And our thanks to Senator Goodwin for introducing that bill on behalf of the judiciary. And with that, I'm happy to answer any questions. I know it's been a long night. If any questions come up in the future, please feel free to reach out to me. I'm happy to answer them.
Thank you very much for your testimony. And just to follow up on 727, we did get the letter of support from the AG's office on that bill. Any questions?
Thank you.
Any questions from committee members? Seeing none at this time, thank you so much for joining the committee this evening and for your testimony.
Thanks very much. Have a nice night.
You too. And just for committee members, we are going to be on our last witness testimony for this evening. And I believe we have Mr. Christopher Arnold on. He'll be speaking on 734, Senate Bill number 34 by Senator DeMario, an act relating to human services, abused and neglected children. Welcome to the committee, Mr. Arnold. I believe you're from the United States Department of Defense, and you'll be speaking on Senate Bill 734.
Good evening, Madam Chair and honorable members of the committee. The Department of Defense is grateful for the opportunity to support the policies reflected in Senate Bill 734 and hopes that Rhode Island will join the 28 other states that have passed similar legislation on this issue. Even one child's life is worth this effort. My name is Christopher Arnold. I am the Northeast Region Liaison at the United States Department of Defense State Liaison Office. I am also a combat veteran. DoD relies on working in collaboration with state and local governments to fulfill its statutory obligation to address child abuse and neglect. While Captain McIver of Naval Station Newport and Angela Perryman, the Regional Counseling Advocacy Coordinator for Commander, Navy Region Mid-Atlantic, were unable to join us this evening, they would both echo support for the policy set forth in Senate Bill 734 and our gratitude to the bill sponsor, Senator DeMario, for helping to codify state policies that already echo some of our best practices, and to the chair for her co-sponsorship of this critical legislation. The bottom line up front, particularly for those that do not know the military way of life, is that unlike civilian employers, the military services have the obligation to know what is happening with our service members and families 24/7. It is part of how we do business. Being a soldier, sailor, airman, Marine, or spaceman is not a 9-to-5 job. Information sharing between DoD and local authorities must be accomplished at the start of investigation, not after adjudication. Federal rule establishes policy and assigns responsibilities for addressing child abuse and domestic abuse through the Family Advocacy Program, or FAP. Formal MOUs between FAP and its counterparts in the local civilian community benefit victims by improving coordination on child abuse and domestic abuse investigations. Senate Bill 734 protects victims and achieves the DoD best practice of having caseworkers ask clients if they are associated with the military, helping connect victims that are identified as military affiliated with the appropriate FAP, rehabilitative, preventative, and other services. Currently in the Ocean State, the present framework relies on an individualized local MOU to guarantee communication between DCYF and the military community. As we have learned in other states, merely having an MOU is not a guarantee that it has operationalized communication and cooperation. Cases which are not referred to the FAP are not afforded the opportunity to receive immediate resources, treatment, and support. Non-reporting of child abuse and neglect cases prevents statistical reporting data. Providing services and managing consistency of information when families are transferred requires a statutory framework, statutory language, and statutory intent to ensure successful outcomes for the benefits of families and the intent of federal law and rule. DoD respectfully submits Rhode Island can assist the DoD mission to protect military children and other youth from abuse and neglect by enacting the policies set forth in Senate Bill 734. Statutory authority will support the development of more consistent MOUs, allowing better coordination of local child welfare and military protective and rehabilitative services in support of military children and families. Madam Chair, DoD appreciates your recognition of the important relationship between the state and local child protective services and the associated military FAP offices in responding and providing support and services to address child abuse in military families, and we ask that you favorably report the policy changes expressed in Senate Bill 734. This is not a military law enforcement matter. This is a victim advocacy measure to protect our most vulnerable. We greatly appreciate that the Rhode Island legislature has been a champion in addressing our key military family quality of life issues for the past 17 years. As always, as the Northeast Region Liaison for DoD, I stand ready to support where I can, and I thank Senator DeMario for her sponsorship and leadership.
Thank you very much for your testimony this evening. Do any committee members have any questions of this witness? Seeing none at this time, thank you very much for your testimony and have a good evening. Okay, that was the last public testimony for this evening. If I could have a motion to adjourn.
Sure.
So moved.
By Senator Archambault, seconded by Senator Reptakis. All in favor?
Aye.
Aye.
We are
Hospitals.
adjourned.